Imagine you've just won a significant arbitration award after months of preparation, countless hours of legal strategy, and substantial financial investment. The arbitrator has ruled in your favor, and you're holding that coveted award document. But here's the harsh reality that catches many off guard. That piece of paper is essentially worthless until you can actually collect on it. It's like winning a marathon, but collapsing just before crossing the finish line. I'm Santiago Cueto, board-certified international business law expert and best-selling author. And over the past 3 decades, I've helped countless clients navigate the complex world of arbitration enforcement. I want to share with you the critical steps and insider strategies for turning your arbitration victory into actual dollars in your bank account, specifically here in the great state of Florida. You see, arbitration has become the preferred method of resolving business disputes, and for good reason. It's typically faster, more cost-effective, and more private than traditional litigation. But here's what most people don't realize. Winning the arbitration is only half the battle. The real challenge often begins when you need to enforce that award against a reluctant or resistant party. Florida has its own unique landscape when it comes to arbitration enforcement, and understanding these nuances can mean the difference between collecting your award and watching it become an expensive paperweight. The Florida Arbitration Code, found in Chapter 682 of the Florida Statutes, provides the framework we work within, and it's closely aligned with the Uniform Arbitration Act. But knowing the law is one thing, knowing how to navigate the practical realities of enforcement is quite another. Let's start with a fundamental principle. In Florida, arbitration awards are generally given the same force and effect as court judgments. This means that once properly confirmed by a court, your arbitration award becomes enforceable through all the traditional collection mechanisms available for regular court judgments. But getting to the confirmation is where the devil lives in the details. The first critical step is timing. Under Florida law, you typically have 4 years from the date of the arbitration award to seek judicial confirmation. This might seem like plenty of time, but I've seen too many clients wait too long only to face the complications that could have easily been avoided with prompt action. The opposing party isn't sitting idle during this time. They may be moving assets, restructuring their businesses, or preparing their own legal challenges to your award. When you're ready to move forward with enforcement, you'll need to file a petition with the appropriate Florida court. Now here's where jurisdictional knowledge becomes crucial. You want to file in a court that has jurisdiction over the opposing party or their assets. This could be where the arbitration took place, where the contract was performed, or where the defendant resides or does business. Getting this wrong from the start can cost you valuable time and money. The petition itself must include specific elements under Florida law. You'll need to attach a copy of the arbitration agreement, the arbitration award, and any other relevant documents from the arbitration proceedings. The petition must clearly state the grounds for confirmation and demonstrate that the award meets all the legal requirements for enforcement. This isn't a place for shortcuts or assumptions. Every detail matters. Now here's where it gets interesting. The opposing party has limited grounds to challenge your arbitration award in Florida. They can't simply relitigate the merits of the case or argue that the arbitrator got it wrong. The grounds for challenging an award are very narrow and include things like corruption, fraud, evident partiality by the arbitrator, or the arbitrator exceeding their powers. These are high bars to meet, which is generally good news for the award winner. However, don't underestimate a determined opponent. I've seen parties throw everything at the wall, hoping something will stick. They may argue that the arbitration agreement was invalid, that proper notice wasn't given, or that the award violates public policy. While these challenges rarely succeed, they can delay enforcement and increase your costs. This is why having experienced counsel who knows how to swiftly counter these tactics is invaluable. Once you've successfully obtained confirmation of your arbitration award, you now have a court judgment, and this opens up a whole arsenal of collection tools. You can garnish bank accounts, levy on personal or real property, and use all the post-judgment discovery mechanisms available under Florida law. But here's a key insight from my years of practice. The most successful enforcement actions are those that begin planning for collection even before the arbitration award is rendered. What do I mean by this? Smart practitioners conduct asset investigations early in the process. You want to know what the opposing party owns, where their money is, and how they structure their business operations. Waiting until after you have an award to start this investigation is often too late. Assets have a way of disappearing or becoming harder to reach once a party knows they're facing a significant judgment. Florida's homestead exemption laws add another layer of complexity that you need to understand. Florida provides some of the most generous homestead protections in the country, which means that a debtor's primary residence may be largely untouchable even with a valid judgment. However, there are exceptions and strategies for dealing with homestead property, particularly when you can demonstrate fraud or when the property was acquired with the intent to hinder creditors. International enforcement presents its own unique challenges and opportunities. If you're dealing with assets or parties outside the United States, you'll need to consider whether the country in question is a signatory to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. Most major jurisdictions are, that's the good news, which generally makes enforcement more straightforward. But each country has its own procedures and requirements. Let me share a recent case that illustrates the importance of moving quickly and strategically. I represented a client who had won a substantial arbitration award against a company that was clearly preparing to dissipate their assets. Rather than simply filing for confirmation and hoping for the best, we immediately sought prejudgment remedies, including attachment of bank accounts and appointment of a receiver for certain business assets. By the time we obtained our confirmed judgment, we had already secured most of the collectible assets. The key was acting decisively and using all available legal tools in coordination. Another critical consideration is insurance coverage. Many commercial disputes involve parties who have liability insurance that might cover the arbitration award. However, insurance companies don't always voluntarily step up to pay arbitration awards, especially if they weren't directly involved in the arbitration process. You may need to bring the insurer into the enforcement action or file a separate lawsuit to compel coverage. This adds complexity but can significantly improve your chances of full collection. The cost of enforcement are also something you need to factor into your strategy. While many arbitration agreements include attorney's fee provisions that can help offset enforcement costs, these fees still need to be collected along with the underlying award. In some cases, the cost of enforcement can approach or even exceed the value of smaller awards. This is why a realistic assessment of collectability should be part of your decision-making process from the very beginning. Technology has also changed the enforcement landscape in significant ways. Electronic discovery tools can help locate hidden assets. Social media can provide evidence of a debtor's financial condition, and online databases can reveal previously unknown business connections or property ownership. The modern enforcement attorney needs to be as comfortable with digital investigation techniques as with traditional legal research. One final point that I cannot emphasize enough: documentation and record keeping throughout the entire process are absolutely critical. From the initial arbitration through final collection, you need to maintain meticulous records of all proceedings, communications, and collection efforts. These records not only protect you legally, but it also provides the foundation for any additional enforcement actions that might become necessary. The bottom line is this: arbitration awards are only as valuable as your ability to enforce them. In Florida, the legal framework generally favors enforcement, but success requires strategic thinking, prompt action, and thorough execution. Don't let your hard-fought arbitration victory become a Pyrrhic one because you failed to properly plan for and execute the enforcement phase. Whether you're a business owner who might someday need to enforce an arbitration award or an attorney representing clients in this process, understanding these principles and preparing accordingly will dramatically improve your chance of turning that arbitration victory into an actual recovery. If you found this information valuable and want to stay updated on the latest developments in international business law and arbitration, make sure to subscribe to this channel and hit that like button. Your engagement helps me continue bringing you practical insights from the trenches of international business law. Until next time, remember that in arbitration, as in all legal matters, preparation and execution make all the difference. See you in the next one.